1 District Judge of Visakhapatnam District Court and now Chairman at Visakhapatnam. I welcome both of you, sir. As part of this Saturday lecture series, we are inviting jurists, advocates, judicial officers in general and judges from Andhra Pradesh High Court. So in the process, we approached Justice Lakshmana Rao and requested him to visit DSNLU and give his valuable message as well as inspiration to our students. So I requested him to give orientation lecture. So he readily accepted to give a lecture on justice education, need of the hour. Now we know legal education, popularly known as you know, after the advent of British rule and the Commonwealth system introduction in the country, we have the British criminal justice system introduced, particularly from 1773. Of course, Mayor's courts at Bombay, Madras, Calcutta. Then after that we have 1773 Regulating Act. Thereby, Supreme Courts were established at Calcutta, Madras and Bombay. And the Governor General of Calcutta was made as superior, and governors of Madras and Bombay presidencies are under the control of Governor General of Calcutta. Previously, they had some better occurrences among the indiscipline among those governors. So, Regulating Act 1773 brought some uniformity in the administration among the East India Company's rule. So, Lord Impey was appointed as the first Chief Justice of Calcutta Supreme Court, and we all know Rajananda Kumar case and Patna case and Kujara case. Then Cornwallis reforms are there in 1780, and we have 1833 charter, under which the law commission, first law commission was appointed. So, slowly under 1861 Councils Act and High Courts Act 1860. So, from High Courts, the direct appeals are to the Privy Council until 1935 Government of India Act. So, under 1935 Government of India Act, Federal Court was established. So, appeals from the High Courts to the Federal Court to Privy Council. This was the brief legal history, and simultaneously we have the constitutional history also. And ultimately we had the freedom, and we have Constitution of India, and the values for which the Indian society fought against the Britishers were relayed in the democratic process introduced through the Constitution of India. So generally we are talking about the legal education. So legal justice and natural justice. So legal justice oriented administration of justice was generally practiced when there was a conflict between rule of man and rule of law. Rule of law prevails. Howsoever you are high, law is above you. So when there is a conflict between rule of law and rule of life, so in the modern interpretations and justice delivery system, the judicial process, the dynamics of the courts started giving preference to rule of life. So when there is a conflict between legal justice and natural justice is preferred. So in the process, several movements were also there. How the legal education was started in India, we know, Vakil, pleader, barrister, different nomenclature were there for the practitioners of the court. So under Advocates Act, we have uniformity, that we have the advocates now. So Bar Council of India, various bar councils of the state, and all these are there as the regulatory bodies to administer this legal profession. So the judicial process is part of legal profession, and we all know different, what we say, ideologies, different understandings of the issues. So ultimately, the court has to understand. That's why that is what is the trend developed in America, which is also practiced in India also, because there is no systematic research. There is no that much environment to have the research to understand the real behaviorism, the impact of behavior of the judge on the decision. Of course, in practice, we had several examples, but there is a tremendous scope for the researchers to do the research on understanding the jury matrix in Indian context also. Jury matrix in American context was already developed. In Plessy versus Ferguson, the equality was understood by the judges in such a way, equality but separate was equality. Equality was there, but separate treatment between whites and blacks was the decision of Plessy versus Ferguson in 1870s. Until 1958, in America, equality was not implemented in its true sense. In Brown versus Board of Education, in 1958, 6 months prior to the delivery of the judgment, all the 7 judges, out of which 6 judges are white, 1 judge was black. The jury matrix, studying the behavior of the judges and understanding the judgment which is going to be delivered by the judges, 6 months prior to the actual judgment, the result was there. All the 7 judges are going to give the unanimous judgment that equality but separate was inequality. Equality means equality. Equality but separate means when there are 4 first-class compartments in a train, 2 first-class compartments are meant for whites, 2 first-class compartments meant for blacks. Blacks are not allowed to travel along with the whites. So that was the discrimination. In the elementary schools started for blacks separately, whites separately. The black student was not allowed to study in the school meant for the whites. Brown versus Board of Education. Brown, a black student who wanted to get the admission in white school, was rejected the admission. Then he went to the Supreme Court. So there, 6 months before the actual judgment, the jury matrix showed that now the judges are in a position to understand equality means equality, equality but separate is inequality. So that type of jury matrix is there. The American realism. Now in India there is a tremendous scope of research to study the Indian realism. There is no textbook, there is no book, there is no researcher who did research on Indian realism. The reason is a lot of things are there, but the other day also I mentioned about this. You take Justice Krishnaya, you take Justice Channapuri, you take Justice Bhagavati. So in the rudimentary stage of developing this public interest litigation, when public interest litigation was started, Justice Hidayatullah and Tulza Furkar bitterly opposed that system. When a regular litigant coming to the court, at the cost of the regular litigant's time, Why should you allow the public interest litigation? Some criticized it as paisa interest litigation. Some criticized it as publicity interest litigation. But ultimately, of course, S.P. Gupta versus Union of India in judges transfer case first, it was constitutionalized. Public interest litigation is authorized by the Supreme Court. So why I am telling all these things? Now the judiciary, represented by learned people, Lakshmana Rao garu, so many judges are there, judicial officers are there. The continuing legal education, of course, the judiciary also recognized it. So once a law was there, a person was appointed and given the responsible post, it is not sufficient. It is a continuing legal education. So through the various training programs for every month and every 2 months, judicial academies are there, National Judicial Academy was there, is there, and state judicial academies and all these things are there. So that's why in the process we should all know about the developments. So why we are comparing the American judicial system, American legal system? Because more or less we adopted the constitutional supremacy, we adopted the judicial process, judicial review from American model. So what are the Indian problems? Americans are also seriously thinking the cultural aspects of the Americans. 2 days back I attended one American embassy meeting where their cultural meeting, they had all these problems. So they are also understanding the real social, economic and political issues of the country. The reason is the problems faced by the Indians may also be faced by the Americans. Small example, the Indian culture, Indian marriage system. When marriage is over, wife and husband having 1 or 2 children, when there is a dispute, wife leaves the husband's home and coming to the parents' home. In America, practically, Americans, the team is working 28 cases from Andhra Pradesh, 22 cases from Telangana, where mothers brought their children when the dispute arose to India. But the children was born in America, the child became the American, child became American citizen. So he is an American citizen. So under American law, squarely it comes under kidnapping from the country. So of course the discussion was also there in a small meeting. So Hague Convention discussed about all these things, where India was not a member to the Hague Convention. Now how to solve these problems? So the American embassy has this particular problem to solve this, because in India we have mother is the natural guardian. So there is no wonder when mother takes the children from the father when there is dispute arise. But in American context, conflict of laws. So all these are very, very important issues to be understood. And as a law student, you should also know all these things. And Justice Lakshmana Rao garu obtained his PhD from Andhra University, and he is continuing his legal education. Even now he is the present scholar, LLD scholar of DSNLU. So we are fortunate, Justice Lakshmana Rao garu is our LLD scholar. So I welcome Justice Lakshmana Rao garu to share his thoughts with our students. Thank you.
At outset, I congratulate the first year students here for joining the prestigious law college. When I go back to my good older days, I studied my law degree in a local college. They're fortunate here. They're studying in a national law college. So I hope that when you come to my age, you will attain greater positions, as by admitting here, you achieve more than my friend Lakshmana Rao and me, as we studied in a local college. I request you to read the law with passion. You know well, in the initial days, we'll think of that. But that should be basic instinct for the law students till their death. This is my personal view, taking cue from professors and experts. You know well that we have 4 stages of this process. One is ignorance, first stage. Second is getting awareness of particular thing. The third one is learning. Fourth one is mastery. Personally, to convey something from my end, I may be at second stage, at knowing stage, or third stage, at learning stage. When we take the case of Justice.Y.Lakshmana Rao, mastery. So you take the inspiration from Justice.Y.Lakshmana Rao. And one more thing, I request you to debate whenever a session is going, involve, visualize the situation and pose the queries, reasonable queries, so that with their expert knowledge they will guide you. Then you can go beyond the classrooms and you can literally reach the courtrooms from your college days. That's the thing. I will pose a point here for just discussion. We have so many legal principles, but where to invoke, where it applies, there is much confusion for many. I will put it this way. We have a second principle that accused shall be presumed innocent till his guilt is proved. Most of you know that. Second one is bail is right, jail is exception. Very good. These 2 principles are on one side. The other one is that if you are a judge or investigation officer or an advocate or prosecutor, when you are examining the case, for bail at least, we will take that aspect first. Are you supposed to examine his criminal antecedents? Are you supposed to examine the criminal antecedents at bail stage? That is at initial stage. Are you supposed to examine or not? Yes. Then how you will reconcile? Accused shall be presumed innocent till his guilt is proved. He has right to bail, jail is exception. How you will play these 3 principles? The student here is answering. We have to see his criminal antecedents at the stage of bail. Then you answer these 2. His guilt is not at all proved. It is just bail stage. Even not the case is subjected for trial or initiated for trial. Are you supposed to examine? We have famous judgment of Justice Krishna Rao, which is landmark even now, that is in the field. Bail is right, jail is exception. 95% in our country believe this principle, ignoring that the same Justice Krishna Rao explained the parameters for bail, that is criminal antecedents, gravity of the offence and all this. And I will read you 2 lines of his judgment. That is, third place, it is the duty of the court to inquire the criminal antecedents, third place bail orders of these criminals, that is offenders. Enable the offenders. I want you to complete the sentence. I will start again. The court has duty to inquire the criminal antecedents, but without inquiring all these, the court granting thoughtless bail orders enabled the offenders to exploit the bail and commit crimes on the members of the society. This was the finding of the Hon'ble Justice.Y.Lakshmana Rao. But I am sure that 95% will not teach this dimension. They will take us to bail is right, jail is exception. When we take a session for rights of the accused, they will enumerate more than 100. I welcome that. But when we take a session for what are the rights of the victim, most of the guys could not rise to the occasion. That's the stage where the system is lagging behind. So now Justice Lakshmana Rao will take us to justice, education and bounds and beyond that. I hope that you all will enjoy the session, and I request you finally to please debate these principles, whichever you hear from the eminent faculty, how they play and their interplay, what is the general rule, what is the exception, then we can gain something. Thank you for giving this opportunity. Thank you.
Lakshmana Rao Garu. Sir was born in 1975 in Prakasa district and pursued his schooling in Prakasa district. Sir, while studying BA LLB in VR Law College, Nellore, was awarded gold medals in criminal law and company law. He completed his post-graduation in Constitutional and Administrative Law, so received his doctorate in law from Andhra University, Visakhapatnam. Dr. Rao's judicial career commenced as an additional district and sessions judge Eluru, West Godavari from 21st February 2014. He also worked as the chairman cum presiding officer of Industrial Tribunal and Labour Court, Anantapur. Sir has also served as a principal district and sessions judge in Krishna at Machilipatnam before he was appointed as Registrar Judicial High Court of Andhra Pradesh, Amaravati, as additional judge of High Court of Andhra Pradesh on 24 January 2025. Thank you for your presence here, sir. I now request our chief guest to address the gathering.
Mr. Alapati Giridhar, Chairman, AP State Value Added Tax Tribunal, Visakhapatnam. Now, I would recognize my best friend, my roommate, my classmate when I was studying BA, BL in VR Law College, Nellore, Professor Dr. Kondaya. He is the professor of Aurangabad National Law School. I recognize my dear friend's presence here, Professor Dr. Kondaya, the teaching faculty of this august institution, my dear friends, students, a warm good afternoon to all of you. I also recognize my colleague, Judicial Officer, Mrs. Vijay-Lakshmi, the jurisdictional magistrate here. I would like to make this session like a debate-oriented session. The concept of today, justice, education, need of the hour. Sky is the limitation for this. But I wanted to deal this topic on a regular basis so that my insights, my thoughts would be shared to you. And I would also welcome your expressions, your views, your thoughts. I believe most of them are, sir, they are all freshers. So how many of you are freshers? Just raise your hands. Oh, very nice, wonderful. As rightly, kindly, just relax. My friend Giridhar rightly pointed out, when we were studying law, we do not have the opportunity of this National Law School's establishment. I did my graduation in law in the year 1994 from 1994 to 1999. At that time, only one or two colleges, National Law School was there, and recently Nalsar was established when we were going out. Our Vice-Chancellors are pertinently raised about one important aspect. that is relating to the disputes between NRIs of America. When I was functioning as the Registrar General of Andhra Pradesh High Court, a team of Consulate General people of United States of America, they have come and met me. They had a problem relating to the child custody between the mother and father. The two people, the mother and father, they have gone to United States of America. They were living there. They were blessed with child. They got a problem, maybe a divorce problem or personal reasons. They have some problems. What happened? Most of the cases where the spouses have got the problem, the mother, she used to bring back the child from abroad to India. Mother, without the consent of the father, taking away the child from America to India. In India, as rightly pointed out by sir, till the child attains 6 years of age, mother is the natural guardian. After that, depending on the facts and circumstances of the case, the judge would decide to whom the child be given for custody, either for the father or the mother. But as far as possible, most of the cases, child will be till it attains the age of 6 years, it used to be in the custody of mother. Now what happened is the mothers, because of the bickerings between her husband, they brought back the child without informing to father. This is an offence in America. This offence is called international child abduction. We have abduction in one of the offences in IPC, but in America it is international child abduction. Whereas for India, we have not recognized this as one of the offences. Penal provision is not there. America, it's penal provision. It's a penalized issue. And there is no convention in between America and India on this aspect. Therefore, the Consulate General people, they are mulling over about sorting out this issue. They came and they sought for our advice. We said them, let us have a dialogue, a document in between the America and India about this issue. If there is a document, if there is a covenant, if there is an agreement in between the two nations, then our parliament would be empowered. Of course, we have that power, but mutual recognition, mutual understanding, mutual sharing of the problem, then we will have our enactment on this aspect. So now this is a burning topic. International child abduction is a burning topic. It is unfortunately happening only for the Indians. We don't know the other scenario, but Indians, we have this problem. And what I have noticed, now I am dealing with the criminal matters. We have a roster system. Unlike the judicial officers, when we post a judicial officer to a particular court, the judicial officer is expected, is bound to do the judicial functioning. If he is posted to civil court, he will be called civil judge junior division. If he is posted to criminal court, he will be called junior judicial magistrate of first class. Unlike that system, we have a roster system called, and in that I was asked to deal with these issues like criminal revision cases, criminal bails. So when my brother Giridhar was referring about the fundamental right of an under trial prisoner, for the first time in India, the Honorable Apex Court in Balchand versus State of Rajasthan said bail is a right or a rule, jail is an exception. When the investigating officer finds that a person, an accused, has committed an offence and he collects prima facie information about the commission of offence, then he would submit a report to the judicial magistrate of first class. That report is called remand report. Remand report is, in simple terms, prima facie the investigating officer comes to conclusion that a person has committed an offence. Some accusation, a well-founded accusation, is submitted before the judicial magistrate of first class. Then the judicial magistrate of first class would remand or would send the accused to the judicial custody for 14 days normally. But it should not extend beyond 15 days. Normally, our people send the accused to the judicial custody for 14 days. So, when he is sent to judicial custody for 14 days, having alleged to have committed an offence, a cognizable offence, a non-bailable offence, then counsel engaged by this accused would file an application for enlargement of the petitioner on bail. Then, during the hearing of the petition, this concept would come. Sir, please presume that the accused is innocent till the guilt is proved. This is the cardinal principle of criminal jurisprudence in India. Since you have not been taught about this IPC, perhaps it may be a bit boring to you, but once you are taught the IPC and this Criminal Procedure Code, now BNSS, you will be loving to hear these concepts. So basically our litigation is of three types: civil litigation, criminal litigation. Other than these two, we call miscellaneous litigation. But what happened recent times, criminal litigation, civil litigation have taken a second seat, back seat, and this miscellaneous litigation is going ahead. But I want to know from my dear friends, how many of you, the freshers here, or second year, third year, or 4 year students, how many of you want to become legal professionals? That is, you want to become an advocate. How many of you want to become advocates? Very good. And all these questions would be pertinent. So please cooperate with me so that I'll also have some understanding. And how many of you want to become judicial officers? Okay, very good. How many of you want to become business people based on this legal education? So we have seen advocates, we have seen judicial officers, and a few are business people, and rest of them, for what sake they are studying this law education? Okay. There is a saying, law is not a single pursuit course. Law is not a single pursuit course. It can be studied along with some other courses like company secretary, chartered accountant, and some other courses. How many of you would agree with me? And how many of you have this idea of studying this law along with company secretary? How many of you want to do? Anybody want to know about it? Or at least anyone have some idea about it? Okay, very good. So a few, 4 or 5 people, they want to study this law along with company secretary. How many of you want to study this law along with chartered accountancy? Okay. Well, when we were studying, my dear friend Kodaya, professor, he studied the company secretary also while he was a law student. He studied the company secretary course also. It has got its own advantage. But my request to you all, rather my suggestion to you all is that, so have an idea, have some clear-cut idea have some rudimental and fundamental idea about what you want to become in future. This is very important. The 5 years course which you are pursuing here would be a path, and rather it would be a stepping stone for your future endeavors. We have seen IAS officers' children becoming the IAS officers. We have seen IPS officers' children becoming the IPS officers. We have seen the judicial officers' children becoming the judicial officers. We have seen the lawyers' children becoming the lawyers. So, if we have this clear-cut idea at the threshold of this course, then it would be very, very useful to you to achieve your goals. When I was studying law, my desire was to become a district judge direct recruitee. My desire was to become a district judge direct recruitee, and some of my friends used to call me like a third ADJ, because we have a court in Nellore. In that court normally direct recruited district judges are posted, and our friends used to go to the courts and see the direct recruited district judge there, an charm personality is there, and having seen them, my friends used to come to my room and our college. They used to tease me that you are third ADJ. So when I went to my court complex at the first instance, I happened to see a direct recruitee district judge in our college. His name is Justice Sitaramurthy. He was the third additional district judge in Nellore. He was a direct recruitee district judge. Having seen him, something was imbibed in my mind without my volition, that rather I emulated him, that no, I should become like him. So it was there, not knowing to me, it was there in my mind. After a few years, I saw him in my first year or second year. After a few years, like in fourth year or fifth year, again I saw a direct recruitee district judge who happened to hold the same post. He was Justice U. Durga Rao. Both later became celebrated judges of the High Court, Justice Sitaramurthy Garu and Justice Durga Rao Garu. So I had seen them, knowingly or unknowingly, I emulated their personality. I decided myself to become a judicial officer. So this is very important. This decision may be changing during the course of your study. But if we have that desire, let that desire be flared up. If you do not have that desire, just ponder over yourself. Yes, what is my goal? What is my ambition? If we have a clear-cut idea about it, it would be very easy to get through it. It would be very easy to crack it. It would be very easy to achieve that. So coming to our topic, this justice education, sky is the limit for this. But as I said earlier, I want to proceed from a different perception. Probably your faculty may be teaching about this concept, but I want to a book in your mother's bookshelf, or a book in the hand of your grandmother or grandfather. How many of you have studied Mahabharata? Very good, very good. Ramayana. So I suggest there are two good books on these two great epics. It would give you different ideology. Your philosophy would be changed once you read it. So in Mahabharata, this is very interesting because we are dealing with justice education. In Mahabharata, it is divided into several parvas. Now we are dealing with the 12th parva, that is Vanaparva. Vanaparva means Pandavas, after they lost the game of dice with Shakuni, supported by Duryodhana, they were sent for exile for 12 years. They had to spend their life in forest. After completion of this 12 years of exile in forest, they were also supposed to undergo 1 year Ajnatavasa. That means they have to live in incognito. Their whereabouts should not be known to anyone. Once their whereabouts are known, then if it is found, then they have to go for 12 years Aranyavasa and again 1 year incognito Ajnatavasa. When they were these Pandavas, how many of them Pandavas? 5. There are 5. Dharmaraja, Bhima, Arjuna, Nakula and Sahadeva. They married one pious lady called Draupadi. What is that type of marriage? In your sociology, you will be knowing about what is that kind of marriage? Polyandry marriage. Sacred marriage. Of course, that marriage is not being recognized now by virtue of Section 5 of the Hindu Marriage Act 1955. Bigamy is abolition. Bigamy is prohibited. Because of this, only our Hindu society is now marching ahead. Kudos to our great legal exponent, Dr. B.R. Ambedkar. Because of his efforts, we got Hindu Code consisting of Hindu Marriage Act 1955, Hindu Adoption Maintenance Act 1956, Hindu Succession Act 1956, Hindu Guardians and Wards Act 1956. These 4 wonderful pieces of the legislations we got in kind of Hindu Code in the year 1955 because of the efforts made by Dr. B.R. Ambedkar, the chief draftsman of our Indian Constitution. So when these Pandavas were in that, they have completed their 12 years successfully exile called Aranyavasa, and they were about to enter into 1 year Ajnatavasa, that is incognito. They were just thinking of how to spend very carefully and consciously this 1 year of incognito. And they had happened to see one Brahmin. That Brahmin approached them, and incidentally these Pandavas, head of them Dharmaraja, who performed Rajasuya Yaga and later having lost in the game of dice, he was in the forest. He asked the Brahmin, "Sir, we are going to spend our life in incognito for 1 year. Could you suggest us the best way to be incognito to anyone?" Then this Brahmana, he was telling that, "Sir, I will tell about that, but just I have a problem that my arani, that is 2 wooden blocks used for creating a fire. If some friction is given to these 2 wooden blocks, fire would generate automatically. That is being used for performing rituals. In good olden days, for performing ritual, they don't have this matchstick, they don't have this camphor, they don't use it, they are not supposed to use it. They create the fire by way of friction with these wooden blocks." He said, "Sir, my wooden blocks, that is called arani, was taken away by one deer with his horns. It has taken away. I want that wooden blocks, sir, arani." Then the dharma of Kshatriyas in those days was, whenever a Brahmin asked anything, rather not only Brahmin, let alone a Brahmin, anyone ask, because this is the Raja Dharma. Raj is the king is expected to provide whatever the people of the subjects are expecting. In fact, the elementary understanding of justice is that only. How many of you know what is justice in simple terms? Not legal parlance. What is your level of understanding about dharma? Can anyone of you say? Simple word, dharma. Dharma, in other words, called justice. What is meant by justice? Can any one of you say simple terms, very elementary level terms? I tell you, Dharma means, in simplest terms, provide to other what he is due. Provide to other what he is due. This is the simplest and the correct understanding of the term Dharma. Say for example, let us take a father and a son, a father and a daughter, a mother and a daughter or a son. What is the Dharma of father towards a son? I expect answer from this side. What is the Dharma of a father towards his son? Bringing him up, isn't it? Provide food to him, provide shelter to him, provide wonderful education to him, provide decent life to him within his economic resources. This is the Dharma of father towards his son. What is the Dharma of mother towards her daughter or son? This side. What is the Dharma of mother towards her children? Dharma of mother is to feed her children, to feed her child, to cook for her, to cook for him, to bathe her, to bathe him. This is the Dharma. What is the Dharma of a teacher towards his pupil? Teaching, imparting education is the Dharma. So, at rudimental level, Dharma means what? Providing to other what the other is due. This is called Dharma. Now coming to our story of Vanaparva in Mahabharata, the Dharma of the Raj, the king, is to give what he lost. So Dharmaraja and the four other brothers, they had gone to forest in search of the deer which has taken away this Arani, 2 wooden blocks. They were tracing the prints of the deer. They were proceeding in the deep forest. After going some distance, Dharmaraja felt thirsty. He was thirsty. Then he asked his junior-most youngest brother, Sahadeva, Sahadeva, I feel thirsty. Go and fetch water for me. Sahadeva, 5 brothers, they are very, very affectionate towards each other. Sahadeva, he went in pursuit of fetching water. Ultimately, was there in the pond. He went to the pond, a water pond, very pleasant water was there. Hitherto he had never seen such a wonderful, beautiful pond. He went there. No creature was there in that pond except one crane. This crane, having seen Sahadeva, told him, "Look, Sahadeva, you are not supposed to enter into this pond and take water to quench your thirst and also bring the water to your brothers unless you give answers to the questions posed by me. Without heeding this request, if you go into the pond, you will soon die, because if you do not answer these questions and drink water, water would become poison." Without hearing this, Sahadeva went into the pond. He drank the water with his hands. Soon after, he died. Instantaneously, he died. After some time, the 4 brothers saw why the Sahadeva not come back. Then the next junior most, that is Nakula, he was asked to go and find out where the Sahadeva gone and bring water for our Dharmaraja. This Sahadeva went there and he also went to the pond. He also felt the same beautiful scenery and he was about to take water. this crane, that crane again asked the same question. Nakula, if you do not answer the questions and drink water, you would soon die. You would go to the same fate of your brother Sahadeva. But Nakula also didn't heed it, and he went there and drank the water, and he also immediately died on the spot. Again, the turn of next brother Arjuna, he went there, he also faced the same fate. Later Bhima, the most powerful man, he also faced the same. Now it was a turn of the eldest brother Dharmaraja, who is considered to be an embodiment of Dharma, an embodiment of law, because he was born because of the boon given by Lord Yamadharmaraja. So he went there to the pond, he noticed the pond, very beautiful pond, and he also noticed a crane there. He asked, this crane asked this Dharmaraja, Dharmaraja, your 4 brothers have died here. Unless you answer the questions reasonably, you drink the water, you will also die. And the crane, it is in the disguise of, the crane is actually an Yaksha. It is in disguise of crane. That's why it could able to speak. Then this crane, disguise of Yaksha, asked Dharmaraja. Dharmaraja said, he realized that, oh, there is some difficult situation here. Unless I do not ask all these things, tell all these things, I would also face the same fate. Then Dharmaraja realized that so there is some imminent danger. He decided to answer the questions posed by crane. Crane, the Yaksha, asked more than 100 questions. These are all the questions relating to our metaphysics, our human life, our philosophy, and the essence of the entire universe. The Yaksha in fact wanted to test the intellectual prowess of Dharmaraja. So several questions were asked, but all those questions were not pertinent to us. Only a few questions, 4 or 5 questions would be pertinent to us. Then now I am just displaying or exposing these to you. Yaksha asked Dharmaraja, Dharmaraja, what is the source of power that is in the sun? What is the source of power that is in the sun? You know, what is the basis for us on this earth? Earth is our basis. Without earth, we can't be. First, our mother, that is why we call Matru Devo Bhava. Next, our earth mother. The earth mother revolves around sun. So, our ultimate basis is from sun. Yaksha asked Dharmaraja, what is the source of power on which Lord the Sun is in the universe? Without any hesitation, Dharmaraja said, it is Brahman, Lord Supreme. Next question asked, what makes or what causes the sun to set? How many of you know Telugu? Oh, very good. And Hindi? Oh. If I tell it in Telugu, there will be punch. Dharmaraja, సూర్యుడిని అస్తమింపచేస్తున్నది ఎవరు? Dharmaraja, who is causing Lord Surya to set? Dharmaraja, without any hesitation, within fraction of seconds, he said, Dharma is causing set sun. And this Yaksha again asked, and who is rising the sun, or who is the root cause for establishment of the sun? Then Dharmaraja said, this is the truth truth is the basis or the truth is the establishment, truth is the powerful source based on which Lord Surya is functioning. So, Lord Surya is functioning sunset, sunrise on two aspects. That is, one is sunset dharma, sunrise is justice, that is truth. So, justice and truth are the two important aspects that is ruling the universe. Not we are just after all human beings. Lord Sun is functioning based on the two principles, setting, dharma, rising, standing on the truth, principle of truth. So now you can understand the importance of the truth and dharma. Truth and dharma are the two coins of two shades, two parts, two faces of one coin. While we are administering oath to, if you become the judicial officer, you will have the occasion of recording the evidence of the witnesses. This is called administering the oath under the Indian Oaths Act. Before taking into consideration, before recording any statement of a witness who has had some acquaintance with the facts and circumstances of the case, then we record his statement. Before recording his statement, we want to inform him that you must speak truth only and nothing but the truth, whole truth only. So, before recording that, we administer oath under the Oaths Act that I should speak truth only, the whole truth only, the nothing but truth. So, this is called oath. Oath, truth has got such importance in our system. Next one is dharma. So I said simple words, dharma, what we need to do for the other, who is due for that. These two concepts, if we take literally, spiritually, actually into our mind, then we will become wonderful human beings. You know, what is the reason for Mahatma Gandhi, Mohandas Karamchand Gandhi became Mahatma of our nation? Just because he resorted the truth. Some thousands of years ago, a king was ruling our universe, our world. He is called Harishchandra. Still now we tell about his greatness because he resorted to Satya, truth. So truth has got that much of importance. Why I tell this truth is pertinent to the legal course law students, I tell you, it's very important for us. Not like speaking the truth. Here my understanding and my request to convey is inner truth, inner integrity. You have to be true to yourself. You have to be true to yourself. If you follow this inner integrity, you would rise to the expected levels, your desirous levels. Next, coming to our topic, justice education. You have a wonderful time here, 5 years course, but you have good books in your library. Please pay your attention to read at least important fundamental books that will give you good idea about the subject. What I practiced would only tell you, suggest you, otherwise I won't tell you also. If I practice and tell you, then there is a very possibility of you follow the same thing. We have Ramakrishna Paramahamsa in his life, wonderful story about the sweet story. How many of you know about it? Sweet story, Ramakrishna Paramahamsa sweet story. Ramakrishna Paramahamsa, you know, he is a Paramahamsa. That means highest state of spiritualness, highest state of enlightenment. We have a sloka in our Sanskrit, Hamsa Hamsaya Vidmahe Paramahamsaya Dhimahi Tanno Hamsa Prachodayat. That means Paramahamsa, we call a person as a Paramahamsa. He feels that he is the God. God is in him and he is in the God. He and the God are one and the same. This is called Paramahamsa Tattva in simple terms. Paramahamsa Ramakrishna is a Paramahamsa, Ramakrishna Paramahamsa. He has so many followers, so many devotees, so many ardent devotees, followers. One among them is a poor lady. This lady, the woman, got a son. That son has got a problem. Incessant eating of, frequent eating of sweets. So mother vexed with his addict. Mother went here, she has no other way except going and prostrating before Ramakrishna Paramahamsa and telling her problems. Mother went there. Mother asked Ramakrishna Paramahamsa, Prabhu, my son has got the problem of eating sugar, sweets excessively without any reason, and my financial position is also not in a position to support it. Therefore, kindly bless my son, kindly suggest me, kindly do something so that my son would shun eating these sweets. Then Ramakrishna Paramahamsa, he asked the mother, Amma, you go and meet me after 2 weeks. So she was perturbed, she was in doubt why Ramakrishna Paramahamsa said like that. Anyhow, Guru said, I have to follow. She went her home and after 2 weeks, she again had darshan of Ramakrishna Paramahamsa. Then Ramakrishna Paramahamsa, having seen that boy, son, mother's son, Babu, don't eat sweets from tomorrow onwards. Immediately, mother went there. This child stopped eating sweets. Unknowingly, he stopped without his volition. He got a kind of aversion. He did not like sweets and he stopped eating sweets. Then Ramakrishna Paramahamsa told in his books also to his disciples, so if we practice anything systematically, spiritually and with wholeheartedness, and if we tell that to others, definitely the other people would follow it. Now I tell, when I was a student, my good friend is also here, he also practiced the same. Kondaya, Professor Kondaya. We used to study the fundamental, the important student editions of the subjects. For example, our lecturer was teaching Criminal Procedure Code 1973. We used to refer Kelkar CRPC. We used to study it. Kelkar CRPC. If my lecturer was teaching us Indian Penal Code 1860, we used to go for Achyutan Pillai. If our teacher was educating us on Constitution of India, we used to refer J.N. Pandey, we used to refer M.P. Jain. So, like that, jurisprudence, Triparty, and legal education, Indian legal history, V.D. Kulashrestha. We used to go to these basic books, student editions on the subjects. We used to prepare our own notes. This is very important. We used to prepare our own notes. This is very important for you. Even if you become the lawyer, you need to refer these notes. Even if you become the judge, you need to have these notes. Even for becoming the judicial officer also, preparation of these notes is very, very important for you. What is the success behind any civil servant is his preparation of notes. If you have wonderful notes, you will become a wonderful lawyer. If you have a wonderful notes, you will become a good judicial officer at first attempt itself. So, prepare your notes right now itself. This is very, very important. If you prepare your notes, you have a wonderful advantages. After I finished my law, I joined in the office of my distant relative, Mr. Kakani Subbaramaya, who by that time was 75 years old, had completed his 50 years stint as member of the bar, and he was the president of the Bar Association. I was a teeny junior. He was a stalwart. He did his LLB from Madras University, old Madras University. So he was just referring a certain point on maintenance issue. As I prepared notes and I was thorough with the subject, I said a relevant point to him. Then he astonished towards me and he said, how do you know about it? He said, I studied in law, I prepared notes and I showed my notes to him. And it got, his impression towards me was totally changing. If you become a lawyer, junior lawyer, and go and join the office of a senior, if you are well versed with this, then you will have an added advantage, a good recognition for your senior. Before your senior, you will have your own recognition. So, preparation of notes is very important for you. Please follow it. And in the days to come, after you achieve your goal, you will tell whenever any occasion comes, sir, what you said is right. This is established procedure. And what is the success? What is the secret of the success? Can any one of you tell? What is the secret of success? What is the formula for success? This side and this side, success formula. Very good. And anything more? Success formula. I will tell you. I followed it, I will tell you.
Sacrifice.
Exactly. Wonderful. Very good. Your good name, brother? Excellent, Mr. Gupta. And any other views? Success formula? Hard working. Very good. Who said it? What is your name, sister? Madam, please be seated kindly. Very good, ma'am. Hard work. And anything more? Excellent. Very good. What is your name, brother? Madhu. Very good, Madhu. Very good, very good. So all these are all relevant. Consolidating it, success means an intent, effort and grace. Grace, God grace, your parents' blessings, your teacher blessings are truthful to yourself. Intent plus effort plus grace is equal to success. What kind of intent you need to have to become a judicial officer, civil judge junior division, or a direct district judge, or a directly elevated high court judge, or directly elevating judge of the Supreme Court? What you need to have an intent. What an intent? Not an ordinary intent. A burning desire. A desire to become like that. A desire to become. Whenever you are drinking, the desire is to become that. Eating, become that. Chatting with a friend, no, I want to become that. Burning desire. If burning desire is there, this burning desire would make you to study, effort, putting effort, hard work, smart work, work without any effort less, work with a very simple way, effectively studying, hard work, smart work, burning desire plus effort, your effort, for flawless effort, faultless effort, an effort which one can't blame. This effort is there, efficient effort, wonderful effort, wonderful effort, burning desire, wonderful effort, and God grace would make you what you want to become. This is the secret. And now I am telling you, if you follow, you will become the wonderful personalities, wonderful human beings, citizens useful to the nation, wonderful citizens of the nation you will become. So, we have a lot to know about this justice education. In my experience, as I said earlier, 3 types of litigation: civil, criminal, miscellaneous. Now the miscellaneous litigation is marching ahead. It is governing the rest of the fields. Now let us see the civil litigation or criminal litigation. Initial stages, if you become the lawyer, initial stages grave cases may not come to you. They may come to your senior, and your senior will come and argue. But some simple cases may come. Like what I have seen of these criminal cases, 2 types of criminal cases are there: quasi-criminal, pure criminal. Pure criminal means like bail case, murder, cheating, extortion, dacoity, theft, criminal breach of trust. This kind of cases won a court. And the other one is maintenance cases. Now daily, if I have 50 criminal cases, out of the 50, 35 cases are maintenance cases. Maintenance cases have become, volume of the litigation is very less, cost of the litigation is also very less. Just for 5,000 rupees, she is expecting 10 more thousand, wife is expecting 10 more thousand. Now this litigation is very prevalent. Major chunk of the litigation is maintenance litigation in so far as the criminal procedure code is concerned. In Civil Criminal Procedure Code 125 CRPC, wife is entitled for maintenance, etc. when she is unable to maintain herself. So rest of them, regular theft case, dacoity, murder, etc., etc., etc. And there is another quasi-judicial case, quasi-criminal cases are there. That is Negotiable Instruments Act cases. Section 138 of the NI Act. 138 of the NI Act. It says about dishonor of the check and lawful entitlement, fail to pay the check amount and filing a complaint under section 138 of the NI Act. These 138 Act and NI Act cases are also there. But in your curriculum, I believe that there is no subject on Negotiable Instruments Act. Sir, Vice-Chancellor, sir, now Negotiable Instruments Act is that? Very good. When we were taught, it was not there. Negotiable Instruments Act was not there. But when we were preparing for the judicial officers examination, we were taught about that Negotiable Instruments Act. Now it is also major chunk of litigation. 138 and Act. In High Court, how many of you want to become directly the advocates of High Court? Please raise your hands. How many of you of the pupil want to become the advocates? How many of you directly want to become the High Court advocates? Very good, very good, very good. Good decision. And how many of you want to go to district courts, Mahsil courts, and want to practice there to know about the fundamentals of the procedure? How many of you want to go there? Very good, very good. In fact, both are good. Every step has got its own advantages. So this 138 Act negotiable instruments provisions, they are there in the judicial magistrate of first class level, they are there in the district judges level, sessions judges level, they are there in the High Court also. Same is the case with maintenance also. Maintenance, civil judge, junior division or judicial magistrate of first class, and of course under DVC, Domestic Violence Act, the appeal provision is there, appeal before the district judge, and again coming revision to the High Court. So there are several advantages on that aspect also. Now you can also have your thinking, you can also have your idea, you can fix a notion, or you can take a decision to become civil lawyer, criminal lawyer, or both dealing civil and criminal, tax lawyer. That is also you can have right now. They will have there are very good resources in these aspects also. But whenever you are being taught on a particular subject, have focus on the subject, know about the fundamentals of the subject, and have a free interaction with your faculty. Once you come out of this institution, nobody will be there to guide you, nobody will be there to teach you, nobody will be there to dispel your doubts. You will not be knowing the importance, value of your faculty once you come out of the institution. Then you will repent. Therefore, wise man, wise pupil, what he or she needs to do is have engaged with your faculty, have to spend good time with your faculty. You just express your doubts to your faculty. If it is not possible in the classroom, you can also privately meet the faculty and get your doubts exonerated. This is very, very important. Once you come out of, so all these would be taught here, and have a good dialogue with your teacher. Spend good time with your teacher, get your doubts dispelled, exonerate them. After you come out, nothing will be there. Even your senior also will not be in a position to tell you, because he is not your teacher. You are there to assist your senior, you are there to cooperate with your senior, you are there to go and represent your senior in the courts. So even your senior will not be in a position to tell you, and he won't tell you also. If you have some if you have some knowledge, if you have some ideas, if you tell them, then your senior will be in a position to appreciate you. Otherwise, your senior also will just ignore you. So spend good time with your faculty. This is my one more session. When I was student of law, I used my principal used to recognize me, and Kondai also. My principal, Jayachandra Babu, he used to recognize us by our name. Even now also we are in good touch with him. He has become more than 75 years old. But he considers us like his own brother, his own child. So develop that bond, develop that relation with your faculty. When I said that my initial speech, Acharya Devo Bhava, you will not be knowing the importance and value and greatness of your teacher in the institution. After you go out, you will be knowing about it. So consider your teacher as a representative of Goddess Saraswati, God, and spend time with your teacher and get your doubts cleared. And don't waste your time. This is very, very important. You want to spend some time with your friend. You tend to spend some time with your friend, but that time would not come back again. In the future, it will not come back. The precious moment you are spending here with your books, with the dialogue of the teacher, this is very, very important. When your teacher is teaching you Constitution of India, law of Constitution, it's a wonderful time. Out of his experience of 10 years, 15 years, 20 years, his knowledge, his wisdom, he is sharing that to you. If you want to study the book, it will take more than 20 years for you to at least have some idea about it. Mastery is something different. So, what your teacher has got the knowledge, and her or his experience becoming the wisdom, sharing that knowledge and wisdom to you, that is important. In fact, what is the object of the education? Object of the education is not like receiving some facts, keeping some facts in your mind. No, 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 no. Object of the education is to have knowledge, to have wisdom, to have values. This is the object of the education. Now, the justice education is whatever you are getting imparted in this institution, education, that education should be an education which, by way of which, through which you are going to render dharma, justice to your client. So, the education which you are now learning is the education which you are going to give to your client in the form of dharma. That's very important. A client would come to you with so many hopes. If you have become a judicial officer, a litigant would come to you with so many hopes. If you are equipped yourself with good education, with the foundational education, then you will be in a position to administer justice to the litigants who approach you. If you are perfect in this justice education and becoming a lawyer, then you will be in a position to do 100% justice to your client. This is very, very important. How you will get all these things? Because of paying rapt attention to the classroom discussions from your faculty. I wanted to in fact tell you some 15 to 20 Supreme Court judgments and our High Court judgments touching these nuances of the justice system, justice concept of justice, but surely these will be taught to you by your faculty in the courses. But this kind of, but I consider this as my prelude. This is only an introduction to you. In the days to come, I wanted to come here, I wanted to share my experience, my views, my thoughts about several concepts relating to the justice. So, my request is pay rapt attention to the classes delivered by your lecturers. Have some fundamental ideas about the law, especially the constitution. Very, very important. If you have become mastery over the constitution, nothing is going to prevent you, because the constitution is the grand arm of our country. So, one author says, education is to open the mind of an ignorant. We have our preamble in our constitution. The Honorable Apex Court in Henry Berubari case said, Constitution is, the preamble of the Constitution is a key to open the minds of the constitutional makers. So your education here, justice education here, is going to open your minds to think in a different way, to think effectively, and to render justice to the client who approaches you, to render justice to the litigant who comes to you when you become the judicial officer. Several judgments are there of the Honorable Apex Court, path-breaking judgments. Our Article 14 is the basis on which our justice relies. What Article 14 says? The state shall not deny any person equality before law and equal protection of the laws within the territory of India. Equality, concept of equality, very, very powerful concept, Bayesian concept. Right from the Prime Minister to down to the constable, all are equal before law. Nobody is above law. Just now, either to our Vice-Chancellor sir was telling, whosoever high you are amenable to the jurisdiction of the ordinary courts. You may be billionaire, you may be multi-billionaire, but you are subject to the ordinary jurisdiction of a judicial magistrate of first class if you have violated a law. So, this equality before law, wonderful concept. and equal protection of laws within the territory of India. Another facet of the Dharma, the two concepts, and the important other one, which is the spirit of our Constitution, life of the Constitution. Two aspects. One is Article 21. No person shall be deprived of his life and personal liberty except according to the procedure established by law. This is wonderful. This is the spirit of our Constitution. And Article 32, which itself is a fundamental right. Right to approach the Supreme Court for your grievance, for getting 5 writs. We have 5 writs, and while you are preparing for CLAT, you must have known about it. 5 writs: writ of habeas corpus, writ of mandamus, writ of certiorari, writ of quo warranto, writ of prohibition. For getting remedies and for getting this kind of writs be issued in your favor, right to approach the Supreme Court itself is a fundamental right, which is the heart of our Constitution, even as per according to the words of Dr. B.R. Ambedkar. So this justice education concept is very, very important concept. We can't have a prescribed or a circumference for this concept. This is sky is the limitation for this. And just now my colleague Mr. Giridhar was telling about the rights of the victims. Everybody think of the rights of the accused, but we are not thinking of the rights of the victims. What are the rights of the victims? When an accused is presumed to be innocent till the guilt is proved, and if he is brought before the land magistrate after being sent to the remand, and when he is about to when he is considered for getting released on bail, then we are thinking about the rights of the accused. Article 21, Article 14, Article 22, Article 23, so on and so forth. What is the fate of a victim? What are the rights of the victim? So justice education is very, very important in victim orientation also. We have section 357 of the CRPC providing compensation to the victims. When the court comes to the conclusion that the accused has committed the offence with which he is charged, and what is the justice we are going to do for the victim? Compensation is there. In fact, this was not there in the year 1970s. This concept came out. Bhim Shankar case, Vidyavati's case, and some other cases. The Supreme Court invoked the concept of this tortious liability, fastened this tortious liability on the wrongdoers. Earlier, till 1980s, the Supreme Court declared that going to the hospital for treatment is also a fundamental right. In Paramananda Katara versus Union of India, Supreme Court recognized this right. Yes, citizens have a right to go to the hospitals for treatment. Hospitals cannot deny the treatment. This is a fundamental right. So all these are based on the true appreciation of the justice education. Our Vice-Chancellor sir was also telling about the concept of public interest litigation. Till that judgment, renowned judgment S.P. Gupta's case was there, nobody knows about it. It was alien to our jurisprudence. But later it was recognized, and it has, because of the public interest litigation, so much was done to our society. We have M.C. Mehta, a renowned social spirit man. Because of his proactive measures taken for our society, pollution levels were drastically brought down. Ecological balance was there. Shriram, so on and so forth. So if you study these legal education in justice orientation, your perception would be changed. Once your perception is changed, the same case, if you have justice-oriented perception, the same case, if it comes to you, you will think in a different way and will bring good to your client and will bring good to the system and society. If you do not have that tendency thinking approach, if you are like just other lawyer, if the same case comes to you, you will deal it in an ordinary way. Like a patient has got some inherent problem, but the outer symptom is he is suffering from fever. If you go to an ordinary doctor, he will just give a dolo or some antibiotic and I'll just send you away. But if you are a doctor like a true doctor, you will find out the root cause for the fever. Then you will administer the medicine to that. Then wonderful miracles would happen. Similar way, same problem, sorting out from the roots if you learn the justice education. If you learn the ordinary legal education, then that is altogether different. So, your thought process, your orientation, your approach towards the legal education has to be molded. Responsibility is there on the faculty in this way. So, it's already 1:30. I don't want to bore you more. Normally, there is a psychology, Sigmund Freud's psychology. If we teach anything beyond 20 minutes, unless you are immersed in some kind of jokes and other things, lively interaction, after 20 minutes, you will get a kind of boredom. I take this opportunity to greet you all the best of luck, best of success in your career, best of grace. I will look forward to have some more interactions, but next time I will go deeper into the subject. Whatever the you will take the subject, I'll share my thoughts with you, and you will also be in a position to reciprocate with me. Now, I just want to know from your end, what is your opinion, what is your view about the justice education, and what are your doubts lingering in your mind, and what is your ambition? If you want, any one of you want to share with me, please, you are welcome. This is a question answer session. Anybody wants to have your doubts cleared, and if you have see Spardaya Vardate Vidya, see the pupil, then it would be very, very useful to our system. Say for example, if your teacher asks one question, you do not know about it, that answer is given by your friend, your fellow student. This answer would be registered in your mind forever. How many of you agree with me? This is called Spardaya Vardate Vidya. There is a healthy competition. How this fellow know about it? I do not know. Anyhow, he has known it. No, now this is very good. No. If you read that 20 times, you will not remember it. But once your friend, your benchmate, your roommate, if he says that, if you answer it, then you will not forget in your life. This is the Spardaya Vardate Vidya. Competition, healthy, but this must be a healthy competition. I have seen recently, I don't want to see the movies because, but one day when my children were watching a movie, I was forced to watch it, Mahesh Babu movie. Mahesh Babu later become IIT top person. He became the CEO of a top-notch company. What is the cinema? He went to his village, friend's village, and he wanted to establish his office there. So in that movie, one student, co-student was there with Mahesh Babu. That fellow has got a jealous competition. So don't become like that. Healthy competition. If your friend tells about an answer which you do not know, if your friend tells about a concept which is alien to you, you do not know about it, take it in a good spirit. Because he knows about it, it will be everlasting in your mind. So that kind of healthy competition kindly develop among yourselves. Ultimately, after you come out, your relations would only be everlasting. Now, even now, my friend Kodaya, of course, he is busy with his work and I am busy with my work. But whenever we used to talk over phone, that kind of memories would be there. So spend good time here with your friends. This is very, very important. After that, you where you will be and where he or she will be. So that's very important. In the universe, wonderful relation is the friend relation. Your mother will be there till he goes up. Your father will be with you till he goes up. After that, your friend will always be the friend. Friend, a true friend. A friend not based on some object issues. True friend, have that true friendship. Even God is also expecting a true friendship from his devotee. So, make good friends, have good friendship with others. Friend indeed is a friend in need. So, maintain that relationship with your friends. I don't think that here the culture of ragging is there. I don't think so. If ragging is there, madam here, jurisdiction, madam here, madam will sternly take out it. When I was functioning as principal district judge in Krishna district, a peculiar case was brought to my notice. Not that director of that institution, that's a prestigious central government institution. Nobody brought the management of the institution I did not bring the same to my notice when I was functioning as principal district judge. I saw from the newspaper about the ragging. What happened? I immediately summoned the director, faculty members to the court and I asked them what is going on in your institution. Why you have not taken steps for castigating the students and booking cases against the students, why you have not done? He said he was succumbed to some pressure. I said, if you do not take action against your students, I will direct my magistrate, judicial first class magistrate to book a case against the director and the other professors. Tomorrow, I will direct my judicial magistrate to book a case, take suo motu cognizance against the management. Then they went there and they took stringent action against the students who committed errors. But that situation may not be here. We are all the students in pursuit of legal education. So if we learn this legal education, definitely we will be in a position to render justice to the people. I don't think that you will do in that way. But when I had visited this institution, when I was Registrar General, I saw so many people there. But now I was told that there are several committees constituted in the institution for every purpose. Now the students are also doing well in our education and their behavior towards the fellow students. Well, I am very delighted to have shared my views with you. I look forward to spend some more time with you all. Thank you for bearing me very patiently for this long time. I wish you all the best. Thank you so much. I express my thank you so much. Thank you so much. 2 days of incessantly clapping. Hare Baba, enough you have spoken. The other one is with whole spirit you have conveyed your encomiums on me. My sincere gratitude, heartfelt gratitude to my Guru also, Professor Dr.Surya Rao. I want to tell something about him. He is such a downtrodden personality. Very, very, very simple, very, very, very humble. You will not be knowing about his greatness as long as in the institution. Once you go out, you will be knowing about this. But he is a wonderful Vice-Chancellor. He doesn't have any kind of egoism. He is a friend-like professor, friend-like Vice-Chancellor. In fact, you are all very fortunate to have a wonderful friend-like professor. He mingles with the students. He doesn't have any kind of prejudices, personal predilections. A wonderful personality, and he is very helping man. A great helping hand he is. When you are in need, you will be knowing about all these things. His greatness, very, very helping hand, an ordinary thinking man, wonderful man, simple man, pleasant man. So, having such personality as head of this institution, I would hope and wish that this institution would agar well, would march ahead. I hope and trust that this institution in the days to come will become #1 pioneer institution in the legal education in India, and I hope that you will also contribute your might and your cooperation in becoming this institution, in bringing this institution as #1. Thank you so much. Jai Hind. God bless you all.
Campus. And thank you, sir, for enlightening our students what exactly the importance of truth and dharma. And with hard work, they can achieve their goals, sir, by following their own dharma, in fact. So thank you, sir. Thank you, enlightening our students. Thank you, Ronald. Thank you.